Namaskar.
Good morning, sir.
Good morning.
I have come across some frequently asked questions from a professional colleague regarding nomination of shares. In this context, can you please explain us what is nomination?
You see, as per Section 72 of Companies Act 2013, nomination refers to the act of nominating a person in whom the shares would vest in the event of death of the shareholder. So, notwithstanding anything contained in any other law or any testamentary deposition or otherwise, in respect of the shares where a nomination has been made in accordance with the provisions of Companies Act 2013 on the death of the shareholder, or in case of joint holdings, on the death of all the joint holders, the nominee shall become entitled to the rights in relation to such shares held by the deceased shareholders to the exclusion of all other persons unless the nomination is revoked.
So, the next question which arises is who can be a nominee?
Oh, from nomination to nominee, it's a journey. Okay, you see, as per Rule 19 of Companies Share Capital and Debenture Rules 2014, any holder of securities of a company may at any time nominate in form number SH13 any person as his nominee on whom the securities shall vest in the death of his event.
Okay, sir, understood. So, sir, whether a nominee of a shareholder gets an absolute title of shares on the death of the shareholder?
So you are asking about absolute title of shares. Good question. You see, in spite of the use of the word notwithstanding anything contained in any other law for the time being in force in Section 72(3) of Companies Act 2013, both Section 72(3) and by law 2.11.7 of Depositories Act 1996 cannot be held to exclude the legal heir from their rightful claim over the shares against the nominee. So there is no material to show that these provisions deal with the matter of succession in any manner and to confer absolute title of ownership on the nominee. So there is no absolute title of ownership on the nominee. It is always subject to the title of legal heir.
Very well understood, sir. So, sir, can you please explain any case law relating to Section 72 of the Companies Act 2013?
Why not? Sure. You see, the Honorable Supreme Court decided regarding nomination of securities in case of Shakti Yezdani and another versus Jayanand, Jayan Salgaonkar and others, 2024, 178, CLA 155, Supreme Court. It was held that this arrangement of nominee is for limited purpose of avoiding uncertainty about holder of securities to ensure the smooth functioning of the affairs of the company and continue until the legal heir have settled the affairs of the testator and are ready to register the transmission of shares in his or her name for the purpose of succession law.
Okay, sir, understood. Sir, one more question. Can a nomination once made can be changed?
Very good question. Yes, I will tell you. as per Rule 19 of Companies Share Capital and Debenture Rules 2014, nomination may be cancelled or varied by nominating any other person in place of the present nominee by the holder of securities who has made the nomination by giving of notice of such cancellation or variation to the company in form number SH14. If the nomination is made by joint holders and one of the joint holder dies, the remaining joint holders can make a fresh nomination by cancelling existing nomination.
Okay, sir. Moving forward to the last question for the day, what happens if the nominee dies before the shareholder?
Nominee dies before the shareholder. Okay. You see, if a nominee dies before the shareholders or debenture holders, there is a remedy. As per Rule 19(9) of Companies Share Capital and Debenture Rules 2014, the shareholder can vary the nomination by nominating any other person as nominee by giving notice of such variation to company in form number SH14.
Okay, sir. Now we come to our last segment, that is adjudication of penalties under section 454 of the Companies Act 2013. Sir, please tell us any latest case where Registrar of Companies has adjudicated penalty.
Yes, why not? Under the said section, ROC, Registrar of Companies, is authorized to act as adjudicating authority to adjudicate penalty in case of violation of certain sections of Companies Act 2013. In the case of Zenith Drilling Private Limited, Registrar of Companies Patna, wide order dated 19 February 2024 imposed the penalty of 35,000 on company and rupees 35,000 each on directors for violation of section 12 of Companies Act 2013, that is relating to provision regarding registered office of company under section 4(6) of the Act. Okay.
Thank you, sir.
So, thank you audience. We'll meet again. Bye.